First District Court of Appeal is now in session. All who had business before this court, draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have two cases on the docket today. The first case is Mastrandria versus Snow. Is the appellant ready to proceed? Thank you. You may.
My name is Jack Crumbine. I represent Roland Mastrandria, the appellant in this case. Please, the court.
Will you pull the mic a little closer?
Oh, yes. Do I need to repeat what I just stated, though?
Go ahead.
May it please the court. Would the court like to hear a brief recitation of the facts, procedural history, and how we arrived here? This
Well,
morning?
what I want to know is whether Mr. Mastrandria is a public figure.
Yes, he is a public official, a former public official at this point in time. We're not contesting the issue at here this morning.
Okay, so what's the standard for any kind of libel for a public figure?
Well, it's actual malice, Your Honor, or reckless disregard.
Okay.
And so,
Have you read some of the criticism of the New York Times versus Sullivan decision from luminaries such as Justice Thomas and Judge Silberman?
I have not. I cannot say
They argue that that decision is completely contrary to the text of the Constitution, has no basis in the common law, and should be repealed, receded from. We can't do that. But I was wondering if you might have any thoughts about the deleterious effects of New York Times versus Sullivan as it applies to your client.
I do, to some degree, Your Honor, in relationship to the Florida Section 7.
Because basically under that statute, the media can make false statements about public figures almost with total immunity, as Justice Thomas and Judge Silberman mentioned.
Correct, Your Honor, and I think that what it really does have to do with, and I believe that I've read a little bit, I'm not sure if my memory will fail me, but I think it was Justice Holmes that stated that it was the continuous evolution of the balancing test that had to be treated by the judiciary that continuously eradicates the First Amendment rights to freedom of speech in order for us to be able to live within ordered liberty. And so I think that touches directly on the application of Statute 768.
Because here, there's no question that any comments by the appellee regarding insinuations of unethical or financial improprieties, those were false, right?
Yes, Your Honor, and I believe that in the record it actually speaks directly to the fact that she either knew they were false or simply disregarded whether they were false at all. There are multiple sections in the deposition transcripts that demonstrate to contradictions, later admissions to, for example, language being employed such as whether my client was working directly for the developer or and first denials, then admissions.
And in fact, in this case, it kind of brings to an example of what Justice Thomas talks about in a dissent from certiorari denial, that actually libel against public figures is a greater harm to society than libel against private figures, right? Because
Yes.
here, for example, you can recklessly say a city councilman or someone's acting for financial improprieties or on that basis, and that causes disrespect for the actions of the public body, right?
That's correct, Your Honor, and I think that your point goes directly to Garrison versus Louisiana, 379 U.S. 64, 1964, where there was a publication made imputing crime on, I believe it was 8 judges, and the court stated that although speech concerning public affairs is more than self-expression, it is the essence of self-government, but it did limit it by stating that it does not follow that the lie knowingly and deliberately published about a public official should enjoy a like immunity. And use of the words in that case, racketeer influences in relationship to the judges, suggested an imputed crime, an expression that the judges had enjoyed outrageous, for example, a vacation time, also suggested and connoted a violation of law. In that particular case, malfeasance, analogous to some of the accusations made to against my client for malfeasance and misfeasance. And
Right.
indirect.
For example, in this case, I guess the question is, the line is, because as Justice Thomas notes, even under the law at the time of the founding of the country, you could obviously, under the common law, typically of the states, you could criticize a public figure for public actions by that figure, but you couldn't falsely impugn crimes such as bribery or other immoral acts falsely. So let's look at the facts here. Now, summary judgment was granted, and the question is, your client was accused of financial improprieties by implication, that he was making decisions not based on the merits of the case, but on financial gain, right?
That's correct, Your Honor. And what was very interesting to see and is visible in the transcript of the deposition of the appellee is that the responses were highly evasive to that particular issue.
Right.
Always,
You're right. The issues weren't, well, this development is a bad idea because it'll dump additional stormwater runoff. I mean, those may have been raised also, of course, I'm sure.
Yes, Your
But
Honor.
the issues were, your client is in cahoots with the developer.
Correct, Your Honor, and it was by implication. The responses were statements of fact couched in the manner of opinion. We had an avoidance of providing a direct response by using words such as "we," as if the deponent at that point in time was a representative of a group. We had.
So which of your statements are you alleging were statements of fact versus statements of opinion? Because a lot of them seem to be at least based in opinion.
Sure, Your Honor. And so some of the statements of fact that I see, for example, included, for example, record page 263, and it spoke to unethical behavior of my client in relationship to violations of sunshine law. And the fact of the matter is that the appellee admitted to those statements having been made, really not knowing whether they were true or not really caring whether they were true or not. In fact, there were multiple occasions throughout the record whereby the appellee stated that even if someone had explained to her that her statements were not correct or not.
I think her explanation was, she said, appeared to be, or emphasized appearance of impropriety. So in response to Judge Roberts' question, give us specifics with respect to where's malice? Where's the evidence of malice?
Yes, Your Honor. So on record page 276, deposition transcript 222, paragraph 23 through 25, page 223, paragraph 1 through 8, the appellee states that it would not matter if she had made false statements of fact that were defamatory related to ethics violations of the appellant. And I believe that that shows reckless disregard. I believe that if an individual, another factor with actual malice, Your Honor, is, for example, that she had the opportunity to interview my client to speak to the issues that she had concern with. She also had the opportunity to speak with the developer directly and was provided with a letter showing no financial interest, chose not to interview these individuals. That goes to actual malice, Your Honor, under the case law. So I think that when we look at the entirety of the record, we see that there is perhaps the appellee being entrapped by her own imagination and simply throwing out statements that because of that also fall within actual malice, or at least allow for that to be interpreted that way. Now, that would be under Hardy.
Do you attend a lot of city and county commission meetings?
I do not, Your Honor.
Because I used to in certain other jobs I had, and it seems like there's someone at every county commission meeting that basically stands up and makes allegations such as this against any and all the commissioners, and I guess that's unfortunate. But the New York Times versus Sullivan, whether you agree with it or not, that being the case, I don't know much that can be done about that.
Well, Your Honor, I think that the limitation is whether someone knew what they were saying was false, whether they had entertained serious doubts as to whether the statements were false.
Right, under New York Times versus Sullivan, the evil that has proceeded from that decision is a person can make false statements and not investigate, just hide behind a cloak of purported ignorance and accuse people of all kinds of improper and unethical conduct, and the press has total immunity from making those kind of false statements, right? That's what Justice Thomas and Judge Silberman have commented on regarding New York Times. Now, we're bound by it, obviously, but we certainly can question it and how it applies to a person such as your client here, who's basically been accused of, by implication, bribery.
Correct.
That's
Your-
exactly what is at the crux of this matter here.
Correct, Your Honor, and there was a retaliatory letter that was sent to the Governor DeSantis' office just the day of the lawsuit, and in that letter, the appellee directly implied corruption, malfeasance, misfeasance, and in the deposition admits that there was no basis for that. So I
But
don't know how.
there are a number of people, you got to agree with me, that there are a number of people that are so sure of the rightness of their position that if anybody agrees with them, it has to be because there is bad motive or ill intent. And they really believe that.
Correct, Your Honor, but I think that there's a difference between falling to your own imagination, to one's own imagination, which would be a basis to find actual malice, and having, for example, information from someone that would validate a position, and if that position comes from a credible source, then I think that there is, under the case law, an immunity to the statements made, but that's not the case in this case. In our case here. Now, the other issue for the court to consider is whether the Florida Section 768.925 actually applies if there isn't sufficient evidence in the record for the court to, for a jury to find actual malice at trial. And I bring this up because there are two issues here. We have a remedial statute that should be interpreted liberally. However, there are some limitations based on language because there are two sections. One, the statute does provide for some limitations such as primary purposes of a lawsuit filed, statements made before a governmental institution, but it also provides for limitation in subsection 2A, where it states certain literary types of works that are provided with the guarantees of speech. But the last little section there states other similar works, and other similar works is a broader language that requires interpretation by the court. However, similar works is the issue, similar to those enumerated works, meaning they really do have to be type of literary works. The libel count in this case was mostly based on emails, text messages, private messaging, and that cannot be constituting a work. Now, for example, I make the distinction in the sense that there is something called messaging. A meme, for example, thanks to Andy Warhol, perhaps we can call that an artwork, right? Because it contains a message. A tweet, properly crafted, contains a message. However, private text messages are simply the replacement by electronic media that would allow us today to replace oral communication, live communication, and that should be treated differently because it's not an other work. And so therefore, those types of communications would have to be made before a governmental entity in order for there to be protection, and there's no way that could have been the case. So that's why I argue that that particular statute, section 768.925, does not apply in this case with regard to the dismissal. Now, I have 2 minutes and 15 seconds, and so if I may go back, I know it's a little bit out of order, if I may go back to the issue of the record evidence. A particular
And
issue.
I don't know if you said you were going to reserve any time for rebuttal, so but
May I
that's all your time.
May I reserve 2 minutes for rebuttal at this time?
Yes, you may.
Thank you.
Good morning, Your Honors. My name is Robert Aguilar. I'm here on behalf of the appellee, Sherry Snow. If If it pleases the court, I don't believe I need to go into the question over whether Mr. Mastandrea is a public figure. I think we've decided, I think we all can agree on that point. This is basically a suit that was brought by Mr. Mastandrea as a city councilman, town councilman, Orange Park, sitting politician, over objections to a pet project, a development project in Orange Park. He sent out, or his attorney sent out on his behalf, a number of identical demand letters, some would call them threatening letters. Interesting because they were, in fact, identical except for the names of the addressees. All of them accused of making the same oral statements, all of them accused of making the same statements at the same time and under the same circumstances. Ms. Snow received one of those letters. She was the one who was sued. One of those people, Mr. Reese, whose deposition was filed in the court below, did apologize, a rather strained apology, which was quoted in my brief.
So why wasn't there enough evidence in the record that this shouldn't have gone to the jury?
Let's take a look at.
You have to agree that there possibly is some evidence, if believed by the jury, shows that Ms. Snow had reckless disregard for the truth or falsity of the statement she was making.
I don't believe so, sir, and I'll tell you why. Her entire deposition, which went over 3 days, and was reviewed by the court. As a matter of fact, the trial judge made the point of saying, I'm going to review this entire deposition. And she's asked the same questions repeatedly and gives the same answers repeatedly, that she was giving an opinion. She never said, as a matter of fact, she even said, I wouldn't even know what the words on the take are. I wouldn't use the words on the take. When she was concerned about Mr. Mastandrea working with or for the developer, her concern was that, as she says, very expressed several times, he would go to see the lenders with the developer. Why is he doing that? Why is he working with them? She said she never thought he was taking bribes, and she never thought he was.
You don't think that was a fair implication of her comments?
I think so, sir. I believe so, because working with.
Working with?
A fair application of it.
Isn't it up to the jury to decide what's a reasonable inference from those statements?
Your Honor, considering what are the other statements that I have seen in case law that did not constitute evidence of actual malice, it is what she said is almost bland compared to things, the statements that have been made.
I'm aware. Yes, excuse me. I'm aware under New York Times versus Sullivan, the media is allowed to make false, reckless, outrageous statements against public officials with, quote, near immunity, as Judge Silberman noted, under that case that reversed 175 years of law with no grounding in the text of the Constitution, according to Justice Thomas and others.
I'm familiar with that.
But that is the binding law, fortunately or unfortunately, depending on your perspective. So is it your position then that your client could have actually implied that the appellant was acting on improper financial considerations?
If she had come flat out and said, let's take that as a hypothetical. If she had come out and said, and a lot of these things are on blogs, there's numerous references in the deposition to something called the Orange Park Hub, which was where everybody in Orange Park would sort of meet online to discuss, among other things, this project, which is why, and I'll get to it in a little bit, why I believe the statute, anti-SLAPP statute, comes into play. If she had gone on record as saying something like, I know he has taken cash in a brown bag or something along those lines.
Well, let me ask you the question this way. What did she mean?
She repeatedly said, and this is actually in her deposition, I'm a U.S. citizen, I get to ask questions, what's going on?
In your opinion, what did the appellee statements mean to convey regarding the appellant's conduct?
Well, what she
It
said,
certainly wasn't, well, he should have required more stormwater storage, right?
no, sir, there wasn't,
It
had
certainly
nothing to do with
wasn't,
drainage
it should
or
have been more
anything.
parking spaces required, right?
No.
So it wasn't, none of it went to the merits of the project, right?
It went to the merits of the project.
No,
I
it
think.
went to his motivation, right?
No, I think it actually also went to the merits of the project, as in, do we need this? For example, the project was played up as having great tax benefits. There were questions over that. You know, the merits of the project do not necessarily end with the horizontal improvements and vertical improvements of the project. This goes to the merits of the project as into whether it is in fact necessary, whether it is needed. I think, with the court's permission, I believe it would be unnecessarily narrowing the scope of the inquiry to say it only goes to what the bulldozers and pipe layers do.
Right. So I'm sorry, and I kind of interrupted you. You were
No, not at all,
answering
sir.
about the hypothetical, but again, I'm not sure I heard an answer to
Yeah.
what were the purposes of her comments.
She was-
Looking at it in an overarching manner, was she criticizing the appellant on the basis of the merits of the project, or was she questioning whether or not his motives were improper?
I believe she was questioning the merits of the project and as, why is this happening so fast? Why is it being pushed through?
And what do you think is a reasonable inference to that comment?
Well, let me say this. The reasonable inference is subjective, and I would imagine, and different people might think, well, is it reasonable that, what is she saying, he's on getting the proverbial brown bag full of cash, or is she just tired of him working seemingly hand in glove going to
So
lenders?
is it your view under New York Times versus Sullivan that a citizen can simply imply that a person is acting, not saying that your client did, but hypothetically, can a citizen suggest that a public official is acting on the basis of an improper consideration? And again, could be your client, could be the media, questioning whether a public official is acting on the basis of bribery or some other nefarious motive with no evidence. Is that proper even under New York Times versus Sullivan?
Well, when one thinks of the language that says the need to investigate is not required, and I don't want to say that makes everything just a Wild West show, but if I were to try to categorize and then put my client's language and put it in terms of the case, I would say she fell far short of anything that would be actionable under New York Times v. Sullivan.
Again, I'm not speaking of your client, but we're just looking at it from a rule of law
Of course, sir.
perspective. Can a citizen just say that, does a citizen have to say, I think Judge so-and-so, County Commissioner so-and-so, Governor so-and-so, this could be the media, by the way, which, often is involved in some of these kind of cases,
Many
is
of them.
accepting a bribe. So do they have to specifically say that, or under New York Times versus Sullivan, or can an implication of that be sufficient for a libel or slander suit?
I am very hesitant to talk about implications being sufficient, and this is why. As Judge Roberts has said, you go to a meeting, and I've attended meetings sometimes as an attorney, and not of the town council in Orange Park, that's not my bailiwick, but I've attended tax valuation meetings, Board of Ed meetings, and so forth. And, you could hear somebody, a citizen, say something like, what is going on here? What are you people doing? Why are you doing this? What are you getting out of it, type of thing? If that person then, so one might say, of course, well, that was before the board. What if they go outside and they're out on the street here in the parking lot and they say it? It is still not actionable. It is annoying. It may be maddening to some people, to some politicians. I don't think I need to go into Truman's line about stay out of the kitchen if you don't like the heat. But there is a certain, You know, it's not like how we as lawyers have to put up with lawyer jokes at parties on a Saturday night. There's a certain number of maddening things which occur by virtue of the position we hold and the life we choose.
So public officials, and again, just to shift the debate so it's not particularly about your client.
Yes, sir.
Let's say it's about a media outlet. So a public official has to be willing to accept lies from media outlet that accuse public officials of criminal conduct falsely.
The story of the
Is
question
that
is,
part of the bargain for being a public official?
the question is what was said. If what was said was something that is somebody, I hate to say it, I've heard parties say about a judge, why did he do that? And I've had to talk clients down
Right.
when they say, does he know somebody? Does he? No. He just disagrees with you. That's all. And if I had to tell that person, hey, if there was a third person here and you broke the privilege plane, that would be actionable. I'd have to start wondering, do I now control thoughts? Do I somehow control his thoughts? No, people say things. They ask questions. It's not, there's an enormous gulf. There's a gulf, this chasm between somebody saying, I saw somebody slide a bag of money to him, and saying, God, why is he working with a developer like that? There are degrees. And this, what my client said, at worst, is so far over to one side as to keep as to warrant the summary judgment standing.
Yeah, well, let's pull it back into the specific facts of this case.
Yes, of course.
In response to the summary judgment, appellant filed 2 affidavits. That's it, is my understanding. I can't tell, or it's not clear to me from the judge's order, were those considered or were they not? I know they were filed over objection.
Yes, they were filed over objection. I made sure I objected to them because they were clearly objectionable. And I believe I have the final judgment. I believe it says that further considerations might be, defendant's objections of affidavits offered by plaintiff are overruled as moot. That was so overruled, moot, one might say that's 2 different things. Maybe just disregarded because they're moot, but it says overruled because there is moot. They were moot. But those objections, and I'm prepared to argue those objections, were well founded. Those affidavits were totally insufficient to stop a summary judgment. They were based on statements such as, to the best of my knowledge, things were said in a derogatory fashion, I believe. One of the affidavits said something about on the take, etc., as statements by other people. That's why I filed the objection, because I didn't want that going on the record as being without an objection. There was nothing in those 3. There were actually 3 affidavits. Mr. Mastandrea's and 2 other folks who are non-parties, and all of them had the same shortcomings. They would not, none of them would have been even, none of them contained evidence that would have been admissible at trial. Nothing was, I don't even think the words personal knowledge were used in most of them. They weren't, they were all on, not information and belief, but I believe, something along, I have them right here.
While you're looking at that, I'll ask you another question.
Of course.
And that is, I assume your argument is, and obviously it is, that even if your client doesn't prevail under the anti-SLAPP statute, under New York Times versus Sullivan, everything your client said was not actionable.
That's correct, sir. And I stressed that in the brief, and I stressed that in the court below, that they're not tied to each other. I believe the court was correct on both, but the summary judgment stands on its own. With regard, I'm showing time running out. So the affidavits had language such as, I affirm to the best of my knowledge, I have been instructed, I understand, I hereby affirm to the best of my knowledge. Nobody just put the ball over the goal line. If you know it, say it. But they didn't have it in personal knowledge because the things weren't said. That's why nobody could say that they were said, because they weren't said. And that's why, well, my time is up.
I'll allow you to briefly conclude.
Okay. I believe the statute is applicable. With the court's permission, I could run through the provisions of the statute and tell you why I believe that. When we go into the definitions, first of all, the intent of the legislature to protect the right in Florida to exercise the rights of free speech in connection with public issues. And the public policy, this is all in 768.295. Definitions, when it talks about free speech in connection with
Judge,
public
is it your view that under the anti-SLAPP statute, a statement that would otherwise be actionable as libel or slander cannot be filed no matter whether there was reckless indifference to the truth?
Your Honor, there is the one case, the Materio case, which I cited, which does say that since the suit below was without merit,
No, I'm saying a hypothetical where a media outlet or a citizen makes a false statement with reckless disregard for the truth.
Mm-hmm.
If that were part of a SLAPP context, is that prohibited under the statute, that libel action?
Well, I think we'd have to take one, let me answer that this way. We'd have to take one step back, because the statute says a suit brought without merit, so that would go to the question of was there without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue. Clearly, it's a public issue.
And since under New York Times versus Sullivan, it's almost impossible for a public figure to file a libel action with merit, then it would be barred by the SLAPP statute, would be your argument, right?
Yes, sir, and I'm reading from the statute.
Right.
It's not, I'm not implying,
Right.
I'm going
I
with,
understand.
I'm playing with the rule book the legislature gave me.
I understand. I'll allow you now to very briefly conclude.
Your Honor, Your Honors, the summary judgment itself was proper under both the federal case, of course, and the constitutional provisions, and Florida law, clearly by the cases I cited. And it was within the protection of the anti-SLAPP statute. This statute, I will end with this. I read a description of what a anti-SLAPP case was. It was from a case up north somewhere in Illinois or Indiana, and it said basically an anti-SLAPP suit is a suit brought by a developer against somebody who is complaining that they don't like the project. And I thought, wow, well, that rings a bell. And this is clearly within that statute, and I believe the judgment should be affirmed in full. Thank you very much.
Counselor. I would ask the clerk to award an additional 2 minutes and 50 seconds to the appellant's time, please. Thank you.
Thank you.
Just to address a couple of the points on rebuttal. Your Honor, the developer's project was not my client's pet project. It was simply a project that he was enthusiastic about as a representative of the town, and he felt that by supporting that kind of a project, the town would benefit, including all of its citizens, property owners, et cetera. So again, it's the same kind of issue. With regard to the cease and desist letter that came from my office with the identical language in the body of the letter, with the exception of the names, as you will note, most of the language addressing any of the facts can be interpreted as colloquialism, and that's what that was intended to mean. Now, the rest of the body of the letter includes simply a recitation of the law in order to provide individuals with an understanding of what those standards were with regard to them, and nothing more.
Yeah, I'll ask you this question that I asked your opponent in the McKee case. There are two dissents from the denial of certiorari in that case, one by Justice Thomas and another one by Justice Gorsuch. That case was involved a woman who alleged that Bill Cosby raped her. And the lower courts had ruled that by merely coming forward with her complaint, she had rendered herself into a public servant, a public figure, and therefore was subjected to the almost impossible burden legally of New York Times versus Sullivan. And Justice Gorsuch cited statistics as to how it is essentially almost impossible for a person to sue the media under New York Times versus Sullivan, even where the statements are patently false. And he cites very ominous statistics there about how few libel and defamation cases can survive New York Times versus Sullivan. Given that, it's almost impossible to meet the court-created standard of New York Times versus Sullivan. Under the anti-SLAPP statute, since it's almost impossible to file a libel suit by a public figure, then those cases can never have merit, right?
Well, Your Honor, I think that you are addressing a very important issue, and that is government by the people for the people, and that nobody should have an absolute immunity. And so if automatically filing a lawsuit of defamation by a public figure, and they have to adhere to the standard of actual malice, and a dismissal at summary judgment is interpreted as a lawsuit having filed non-meritoriously, then you're absolutely right. Now the citizen has absolute immunity.
But that's the conundrum we're in here, isn't it?
It is. However, I believe that there are some limitations, and the limitations really come out of, I enjoyed this case. It was a Perk versus Reader's Digest Association, 931, F2D 408, 411, 6th Circuit, 1991. It is persuasive. However, in that case, it was ruled that a plaintiff can present proof of malice in the form of cumulative circumstantial evidence, which is often the only way to prove malice in a libel case. That's why we had to take depositions at this type of length, because we had to get into the mind of the appellee in order to find out, is this person just throwing statements out there without any consideration? Does she actually believe what she's saying, or does she just not care what she's saying? And I think that the evidence shows that she just didn't care what she was saying. She didn't bother to follow up. And with regard to the standard in Sullivan, Your Honor, there has been some development in Hark T. Hanks Communication, Inc. versus Connaughton, 491 U.S. 657, 1989. The court stated that actual malice was found where the defendant declined to interview a particular witness,
Right.
which this appellee did, who could have verified the story, which would have been provided had she cared, and actually declined, and where an earlier article in that case, an earlier article by the defendant showed that it had already committed itself to attacking the plaintiff. In this particular case, if we look at the cumulative evidence, we can find that there
Right,
was
and in that case, which involved a newspaper's allegations that a judicial candidate had engaged in dirty tricks, the candidate won the libel judgment, and it was affirmed by the Sixth Circuit and the United States Supreme Court, correct?
Yes, Your Honor. And
it went to trial.
It went to trial. And in this case, we have, for example, the Orange Park Hub, which is arguably a platform created on Facebook for the purpose of defaming my client. It's being couched as opinion, but it was an attack on my client. Now, Your Honor, if I may, well,
So does
No.
it make any difference whether Ms. Snow is, if she were a reporter from the New York Times, who their job is to go out and interview people and find facts, or just a private citizen who attends the meeting and then expresses their conclusion from what they saw at the meeting?
oh, that's an interesting question. But I think that what ends up happening is that I think the relevant response to your question, Your Honor, would be based on the application of the anti-SLAPP statute, and whether the anti-SLAPP statute could be applied in defense by a public figure if the public figure is sued. So, for example, a newspaper reporter that is being sued by a public figure would still have the defense of actual malice.
Well,
That's a tough question.
I'm gonna have to ask you to very quickly conclude.
Yes, Your Honor. I think ultimately the case provides for a very long record. I think that the depositions really do dive into demonstrating the state of mind that the appellee was in, that there was a targeted approach and intent to defame my client, that there were accusations of criminal conduct that were implied, and my client simply decided, hey, you know what? I value my reputation.
Thank you.
Thank you, Your Honor.
Thank you, Counselor. We'll allow the lawyers to step down briefly and then proceed to the second case. Thank you both for your arguments. We're now here for the second case of Westside Electric et al. Versus Jacksonville Electric Authority and Florida Power and Light. Is the appellant ready to proceed?
Yes, Your Honor, I am. Thank you. I'm glad not to be dealing with a mute button today. May it please the Court, Brian Gowdy on behalf of the appellants and who are the plaintiffs below. I want to try to hit 6 points and reserve 5 minutes of my time for rebuttal. The 6 points I'm going to try to hit is, first, the continuing tort doctrine is faithful to the text, and it is not an exception to the statute. Second is that plaintiff's knowledge or discovery of the facts is not determinative under the plain text of the statute. Third, defendants are asking you to do judicial lawmaking by adopting a common law decision from Texas where there is no statute. Fourth, I want to go over then Judge Kennedy's decision in Suarez, which I think is very instructive and wasn't discussed probably near enough in the briefs. Fifth, I want to discuss the permanent temporary framework and stress that defendants bear the burden of proof under that to the extent it applies. And lastly, the consequences of the defendant's argument. With my first point, Your Honor, it was suggested in the appellee briefs that this is some type of exception to the statute of limitations. We laid out on page 5 of our reply brief sequentially both the statement of what the continuing tort doctrine is and what section 95.03101 subsection 1 states, and they are in essence the same thing. The 11th Circuit, I think, put it nicely in the Tucker case that's cited in the brief, so they were applying Georgia law. What the continuing tort doctrine is, it's in essence the commission of a new tort each day, and therefore under the doctrine that predated the statute but is still part of the statute we contend. The last tortious act is when the accrual starts, and the statute says almost the same thing.
Well,
It's the last. Yes,
Counsel,
Your Honor. I'm sorry.
And I'm interested to massage all these theories, but for me, if we could start off right out of the chute with an explanation about how this case has been pled. And to me, in looking at the first complaint and the amended complaint, you specifically pled what appears to be semantically for permanent damages. So if you've couched the case in those terms and now argue, well, I'm actually not seeking permanent damages, this is more of a temporary type situation, how are you reversing course? And I guess explain to me why you're not pinned in by your own pleading.
Yes, I'd be happy to address that, Your Honor. First of all, I think both sides have kind of taken both sides of this issue. When we're talking about the inverse condemnation counts,
Which has not been appealed. That was
and
dropped.
we've abandoned that. And so, but they wanted to say, it was temporary, and we might have made some of those arguments you said. I would like you, though, to go back and review closely the pleadings, because if you look at the operative complaint, and you have to trace it through, it's a little bit difficult. The judge actually denied our request to add the permanent damages allegations to the nuisance and trespass counts. And so those actually are not in the operative complaint. And the reason it's difficult to follow is if you look at the second amended complaint, they are in there. But if you look at the judge's order, he denied that, and he denied those allegations. And you go back and you look at the amended complaint, and you look at just the trespass and nuisance counts, they're not there. And to the extent there's any doubt about that, Your Honor, I'll be very clear, as I was in the footnote in the brief, we are abandoning those claims. And we did plead, in addition to diminution in value, repair and remediation damages. And you're allowed to plead in the alternative in Florida. And so I hope that answers your question. That's what we're traveling under. It's pled that way in the operative complaint, which you have to kind of stitch together the way the judge ruled. And therefore, given that we've abandoned the inverse condemnation, I don't think that should be a question. Unless, if I have to answer your question, I'm going to go back to my points. But just that I'll just move quickly to the second one. I think I covered that the continuing tort doctrine and the statute are the same. I'd also like to stress that under the statute, we hear a lot about when the plaintiffs knew this and when the plaintiffs knew that. That's not determinative under the text. And actually, it's cited by both parties. The RR case from the Florida Supreme Court decided in 2020, which dealt with sex abuse of children. The court makes it clear in there that under the plain text of Chapter 95, there's only a few torts where knowledge or discovery matters, and those are professional liability, products liability, fraud, and in some instances, sex abuse. Nothing else. Not for trespass, not for nuisance. So why we have a lot of discussion in the brief about when my clients knew this or that, I don't know. It didn't matter when we were talking about sex abuse with children. Not sure how it matters here. As far as my third point, Your Honor, the defendants have constructed a large part of their argument based on a Texas case. Well, in that Texas case, it flat out says there's no Texas statute. We can do what we want. We can make common law. Well, you're not making common law. You're interpreting a statute. So I don't think the Texas case is very helpful. I would also point out, which we didn't point out in the brief, but it says it right in the case, the Texas Supreme Court says our common law is unique. It's different than any other state. And, I mean, I guess we're not in Texas. The Suarez case that then Judge Kennedy wrote, I would encourage you to read it because that is, of all the cases cited, is the one that is most clearly applying this statute, 95.031. Even the SDI case, which we rely heavily on, that Judge Jay wrote, it's applying a statute under 552 that has different language. Judge Kennedy, in that opinion, is applying section 95.031, and he says that under state law, under that statute, the continuing tort doctrine applies. But what you won't see in that opinion is one discussion at all about whether the damage was permanent or temporary. He doesn't engage in that analysis. And there's a misunderstanding, I believe, that that analysis is integral to the continuing tort doctrine. It is not. Go back and read the 1890 case from the Florida Supreme Court, the Savannah Railroad case. They don't discuss permanent or temporary. They parse the damages up in that case. There was $500 of damages, and they said all but $180 of this happened outside the limitations period. That's when the railroad tore up the trees and did all their damage. You don't get that $180, but you can get $320. We have a similar thing here. If they can come in and prove that the salt that predates 2010 or 2011, depending on the defendant, if that salt from that period of time, it's their burden because it's their statute of limitations, their affirmative defense. But if they can come in and prove that salt from that period is what caused this particular damage, then we won't get that money. Now, they're going to have a hard time proving that. For example, one of my clients has large construction-like equipment that's mobile. Some of it probably wasn't even around back in 2010, 2009. So I'm not sure how it was damaged. But just to stay on the Suarez case for a moment, the facts there was that the dumping occurred in 1965 and 66 by the city. And unlike here, there were no subsequent invasions of the property. And that's what's critical for determining when did the last element of the cause of action occur. Because trespass is about invasion, not about damage. It's not an element of the tort. And, then Judge Kennedy had no problem.
In fact, damages are presumed in trespass, right?
Well, you can get nominal damages. If I come and I walk across your property today and I'm not authorized, you can get $1. And if I come and I do it tomorrow, you can probably get another $1.
At least.
But you can't sue me today for what I'm going to go do tomorrow. I'm sorry, I didn't hear you, Your Honor.
I said at least $1.
Well, right. I mean, but the point being, unlike a negligence case, damage is not required. And I would also point out that in some of these historical statutes that are being applied, they use the word injury or damage from when the cause of action runs. 95.031 does not use that word. It's the last element. So therefore in the Suarez case, what they were trying to argue is that because this garbage sat on the property for 30 years, and like a lot of contamination cases, it'll continue to have harmful effects, that somehow that was a continuing tort. And Judge Kennedy rightly rejected that because the invasion happened in 1965. The fact that the damage is later aggravated doesn't get you to extend the statute of limitations. We don't have this here. We have recurrent invasions. It's almost like somebody was across the street, and I've been out to the property. It's almost like somebody's across the street throwing salt across the street onto your property. My hypothetical really wasn't that far from what was happening out there. Insofar as if we do get to the question of permanent or temporary damages, we believe we still win on that basis. The defendants bear the burden of proof, and I would like to remind the court the old summary judgment standard applies. There just came out a case this last week. I'll submit a supplemental authority from the 3rd DCA clarifying that you look at the standard at the time the trial judge applied, even though we're up here on appeal after May 1st. But either way, under either standard, the defense bears the burden here to show that this was a permanent injury. And there was more than sufficient evidence in the record for a jury to conclude that this was a recurrent injury. The salt deposition varied based on the wind and the weather. And as a matter of fact, it stopped altogether when they shut down the plant for a 2-week period, and it stopped when they have now taken the plant down in 2018. But even putting that all aside, the defendants needed to come in and prove, under that old summary judgment standard, that there was just simply no way to abate this salt emission and deposition. And they haven't, there's just not evidence in the record to say that as a matter of law.
With respect to abatability, isn't abatability a factor to be considered at the time of the suit being filed as opposed to some subsequent act?
No, I don't agree. I think, and it's very difficult. I'll agree, and I think the Texas Supreme Court makes this clear. I will give them credit for this. It's a very unworkable standard, this whole abatability standard, which is
Well,
why.
I mean, Texas doesn't use it.
Well, right, but why are we going to put in a statute that doesn't have it, some judge-made standard that's unworkable? I guess I would ask that. But as far as the abatability standard, I think you just look and say, is this type of damage something that could be abated? And, they'll get up and they're going to say, no, it's got to be more than that. I think the case law is very unclear, is what I would tell you on that. But I don't think it's limited to just what happened at the time of suit. I think you're certainly allowed to consider post-suit factors. You're allowed to file a supplemental complaint.
I guess I find Oglethorpe instructive out of Georgia. Noise case where abatability was discussed and the court said in reviewing statute of limitations that the noise had been there the whole time. They could have filed the suit. It was there. You could have filed suit to stop it, et cetera, and so forth. So here, if you recognized the damage was occurring as far back as 05 and 08, what's the difference in those two? What's the difference in the analysis? Why wouldn't Oglethorpe logically apply to these facts?
Well, what I would say
If we were
is,
bound by it, but in theory application.
right, what I would say is could have and must have are two different things. And I'll go back to my trespass example. If I walk across Judge Thomas's or your yard today, it may not aggravate you. But if I do it for the next 100 days, maybe at that point you said, I've had enough, I'm going to sue you. And the point is, let's say there's a 50-day statute of limitation. Well, I'm not going to get any damages, or you're not going to get any damages for what I did during those first 49 days. But you can get the damages for the last 50. And there's nothing, just because I could have sued, doesn't mean I had to sue. And I don't think we should be encouraging people to go out and sue the first time there's a trespass. We would like to, if you want to talk about public policy, we want to encourage people to maybe go over to your neighbor and figure that out.
Well, I mean, I get that, and it's a great argument in theory, but then we have to also look at the public policy ramifications for statute of limitations, and there's got to be a liability at least. There can't be an indefinite liability for corporations, et cetera, and so forth. So how do you push that against the public policy need for statute of limitations in general?
Well, I have two responses, Your Honor. First, I disagree that you should look at the public policy. That's what the legislature does. And it said it's the last element of the cause of action, and that's the test. And the second thing I would say, which is my last point I wanted to get to, is you're basically saying that if somebody trespasses often enough, they can just keep doing it. And there's nothing you can do to stop them. If you don't file within, whatever the period is, 1 year, 2 year of the first trespass, that once they get past that statute of limitations, they can keep dumping on your property, and there's nothing you can do to stop it. And that, I would say, is bad public policy. And I'll save the rest of my time for rebuttal. Thank you.
May it please the court. Good morning. I'm Sonia Harrell. I'm representing the appellee JEA. This morning I'll be splitting my time with counsel for FPL, another appellee, Jason Gonzalez.
May I ask who's going to do the rebuttal? Oh, I'm sorry, you don't do the
That's
rebuttal.
okay.
I apologize.
I'll be happy
10 minutes
to do
apiece.
another rebuttal, Your Honor.
I won't give you a sir rebuttal.
Shoot. This case has been going on for a long time. And for over 2 years in the trial court, the appellants consistently litigated their tort claims as permanent. They sought diminution in value as their damages. They repeatedly said that the salt drift from the power plant was constantly on their property. There was testimony in which they said the salt settles into the cracks and stays there. But later, to avoid the statute of limitations, they wanted to apply the continuing tort theory. But that only applies to temporary torts, not the permanent torts that have been alleged in this lawsuit. The appellants are putting the cart before the horse with wanting to apply the continuing tort doctrine. It's well settled in Florida that it only applies to temporary torts. And a court first has to determine whether the tort is permanent or temporary. And the continuing tort doctrine is justified for temporary torts because of the element of uncertainty. We didn't have that in this case. We had a huge electrical coal-fired power plant that was operating since 1988, well before the appellants purchased their properties. And that's when, construing the facts in the light most favorable to the appellants, that's when salt started drifting onto their properties and landing. Granted, they didn't own the property then, but the claim for trespass and nuisance belonged to the property owner at the time the power plant went online. Once the appellants actually bought their properties, they started noticing salt drift. And in their depositions, they described it as constant. In their pleadings, they described it as ongoing. And this is all consistent with the criteria for a permanent tort. And when it's a permanent tort, you have to bring your lawsuit for damages, past, present, and prospective, all in one suit.
Could you address the question that I asked appellant about how damages were pled here, and perhaps address the response that there was an attempt to amend the complaint, and could you comment on that issue?
Yes, Your Honor. In the amended complaint, which is the operative complaint, each appellant had several counts: trespass, nuisance, and inverse condemnation. In the inverse condemnation claim, they specifically said our property value has been diminished, and they argued that consistently. With the trespass and nuisance counts, they pleaded that we have suffered damages. We have suffered damages in the past, and those will continue. They did not use the magic word temporary tort or continuing tort, but what they pleaded were, in fact, damages for a permanent tort. It didn't have that element of uncertainty that we have in the temporary torts. So that was the pleading that we were working on at the time we filed the motion for summary judgment. Shortly after the motions for summary judgment, back in the fall of 2016, after they were filed, the appellants moved to file a second amended complaint. And the damages provisions were kind of the same. They added some additional counts for FPL, but we objected to that because you can't amend a complaint to avoid a statute of limitations. And so the judge allowed the additional counts against FPL to proceed, but their second amended complaint, as far as the damages go, wasn't vastly different than their amended complaint. Much later on, they tried to do two versions of a third amended complaint. In the first version of the third amended complaint, they still didn't plead damages for a temporary tort. They never in any of their pleadings used the magic words permanent or temporary. They did sometimes say that the damages would be continuing or ongoing, but continuing damages don't equal the application of the continuing tort doctrine. Excuse me. The phrase continuing tort doctrine, that's a term of art that applies only to temporary damages. So their pleading was consistent with the evidence that the damages they sought were of the type that could be obtained in one single action for a permanent tort. And they were always seeking diminution in value. The testimony of the corporate representatives, they talked about how their property had been diminished. One of them was going to have to move. Even to the extent they sought damages for repair or remediation, those were reasonably ascertainable. Even the future damages, we can't predict the future, but it's a standard in litigation that you can have an award of future damages as long as they're reasonably estimable. And that's the standard for a permanent tort. And that's exactly what we had throughout this litigation. They claimed diminution in value of the real property. There was a list of 200 pieces of equipment, and in that list, there were columns for expected value, actual value, and difference in value. And that difference in value was what they were seeking. It was about $2.6 million. That's their diminution in value claim.
Now, the statute doesn't talk about permanent versus temporary, correct?
It does not, Your Honor. The plain language of the statute says when the cause of action accrues. And
that is?
For a trespass, that is when there's an invasion. And that invasion started in 1988.
But it continued.
It always sat there. And just like in a trespass, if I leave I go to your house and I leave a chair sitting on your lawn, and you say, yeah, that's okay, you can leave it there, but then you tell me to take it off, then might I still have a trespass. So you can have a continuing trespass, but it's a permanent trespass in the sense that you know about it, you know that I have invaded your property, and it has that element of certainty. The continuing tort doctrine addresses those issues of uncertainty, and a great
Yes,
example.
I just want to look at the plain text.
The plain text just says when the cause of action accrues.
Right, so, I mean, there's no question your client continued to invade the appellant's property, right?
The trespass was always there. They left their salt
Now,
on the appellant's property.
there might be different degrees, a different amount of salt, but the salt was continually being invaded, if you will, placed on the appellant's property, right?
Yes, that invasion always occurred.
So why doesn't the cause of action on the very last day the salt drifts onto their property, why isn't that a new cause of action?
Well, there are several practical implications with that. First of all, you can't determine which, we'd have, if it invaded for 365 days
But that
each
goes to
year.
a question of fact, right?
Well, sort of, but even construing those facts in the light most favorable to them. Let's say there's 52 weeks out of the year there's a salt invasion. Are those 52 lawsuits? That would be
So,
impractical.
Under the plain text, it just seems that if you continue to invade somebody else's property, depending on when the plaintiff wants to file suit, they can file suit on the last time you invade the property if it's within the statute of limitations.
And in this case,
Tell me why that plain reading, or that reading of the plain language is wrong.
because it's not wrong, it's just impractical, and it's not consistent with the other parts of the statutes of limitation. For instance, Chapter 95.11, which says you've got a 4-year limit, and that runs from the time of the cause of accrual. You would have no statute of limitations if that were the case. Public utilities operate, they put steam, other particles onto properties.
But practicality questions, those go to the legislature, right?
That's correct.
Right.
And again, when the legislature says it's when this accrues,
So let me see if I understand what you're telling us. Mr. Gowdy had the scenario where he walked on Judge Thomas's lawn on a day, and he left. And then he walked on it the next day, and he left. And then he walked on it the next day, and he left. And he said that, it may not bother him at first, but one day, it bothers Judge Thomas.
One
and
day it's going to bother me.
Judge Thomas sues.
yes,
And you're saying the way this case was pled and tried below was not that he walked on his yard and left and walked on his yard and left. This case was pled and tried below as if he walked on Judge Thomas's yard, sat down in the yard, and never left.
that's correct.
And in that scenario, the cause of action accrues when he makes the invasion. So you're saying that below it was tried not as a repeated series of invasions, but an invasion that occurred at one time and lasted for a long time.
That's correct.
Okay.
And at the point at which Judge Thomas says, get off my lawn, then there's no point in bringing the action. It wouldn't make sense, because then there's no invasion occurring. Don't want to eat into my co-counsel's time. I would just ask this court to consider that the appellants knew they had redressable injuries back in 2005 and 2008 at the latest. And they didn't bring the lawsuit until 2014. And at that time, they brought their claims for permanent torts. And the trial judge correctly held that those claims were barred by the statute of limitations, and JEA suggests that this court affirm that decision.
Thank you.
Thank
Thank you, Counsel.
May it please the court, Jason Gonzalez with Schutz & Bowen representing Appellee Florida Power and Light Company. Let me go right to the questions that were just asked by Judge Thomas and Judge Roberts. So the text of 95.031 says that a cause of action accrues at the time the last element of the cause of action occurs. I don't think we have a differing opinion with them over construction of that text. I think they have been misstating what it says and suggesting that the cause of action accrues at the moment of the final act contributing to the cause of action. The cause of action accrues at the time the last element occurs. Trespass and nuisance, that happened the very first day that the salt allegedly left the cooling towers and ended up on their property. The cause of action at that point has fully accrued. Every element has occurred. Now, the continuing tort doctrine, which they have been using, we agree, it's not an exception to that statutory language. It's a judicially created doctrine that is used to address a very narrow class of cases, and it says if you meet the requirements of the continuing tort doctrine, then you don't start the running of the statute of limitations until the last act. Okay, so it just addresses when do you start running that 4-year period, and it puts it at the end. That would help them survive this motion for summary judgment if it applied. But it's the continuing tort doctrine that actually it would say it starts at the end.
Maybe you could help me here. Let's say the power plant spews salt onto the property of an adjacent landowner January 1st, 2005. And then it doesn't for 6 more months. And then on June 1st of that year, it does it again. And then a year later, on January 1st, 2006, it does it again. Then, I mean, I don't recall here, is it part of the defense that the salt was being deposited on the property every single day, never stopping? Perhaps is that your argument?
I don't think it matters that it was every single day or every week. We've covered the temporary versus permanent analysis, and that is one analysis of whether continuing tort doctrine applies. But to your question, there's another defining characteristic that you have to have for a continuing tort, and it's in all these cases, and it is that you have to have a series of separate, independent, or tortuous acts. And then they all combine to create some inseparable harm. That was this court's SDI quarry case, clearly. You had separate, independent, tortuous acts. They would go in there, they would drill, they would place explosives, they'd detonate them, they'd excavate, and then a couple of weeks or months later, they would move on to the next place and do a separate, conscious, independent, wrongful or tortuous act over years. In this case, we don't have a continuing tort because we have one single allegedly wrongful or tortuous act of emitting the steam and it drifting over to their property. That's one act. And
I guess I'm not understanding quite the line we have to draw. And that is if a tort occurs in January and then it doesn't occur for 6 months and it occurs again, and then the tort doesn't occur for 6 months and it occurs again, why isn't the very last tort actionable if it's within the statute of limitations?
If you had separate acts like that, that is what the continuing tort doctrine says. It starts at the end.
Isn't every salt deposit a separate act?
They have come up with this creative argument that I think is very far-fetched, that every time the wind changes direction, they get a new cause of action and the clock restarts. There is no support for that in the text of Chapter 95 or in any of the case law. We started in 1988 evaporating 12,000 gallons a minute for 30 years. It was one act, and it drifts onto their property, and the trespass and nuisance occurred that first day when the salt hit. And when the wind changed directions that first day or the next day, whenever they didn't have allegedly a northeast wind, the salt did not leave with the wind. The salt stayed there, creating the trespass and the nuisance. It was there, and it stayed there the whole time, 30 years of this running. They buy the property in 2000, and then, I mean, this record, I mean, and I'm getting close to the end of my time, and I want to point out for this timeline, it's very important to clarify when they knew, and appellant's counsel just suggested that it doesn't matter when they knew. That's bizarre given what they've argued in their briefs. We're giving them, for the purposes of summary judgment and your de novo review of that, the benefit of the last possible moment, according to their deposition testimony from their witnesses, when they knew. And that was in 2008. It was 2005 or 6 for Westside Electric, for Mr. Beasley and his deposition, for the other plaintiffs. It was sometime in 2007, 2008. Let's give them the benefit for summary judgment of the very last moment in 2008. December 31, 2008. 4 years later is December 31, 2012. The 4-year limitations period has run, and that's a long limitations period. They had a long time to bring the claims. But this, I'll conclude with this. From their brief, page 3 and 4, they say, after noticing the unusual corrosion, plaintiffs took the steps to determine the cause. Part of the investigative process were site inspections under the direction of Kevin Holbrook, JEA's Director of Lab and Water Services. At least 2 of these inspections were in 2013. They're drawing the court's attention to the 2013 inspections. They make no mention of their complaints, Westside's complaints to JEA, and inspections over the particulate drift 7 years earlier. They don't mention it in any of these pages. They're telling the court 2013. The record, page 11,578, which is cited in our brief. Question, and this is an incident report. Answer, yes. And this is Mr. Holbrook's deposition. And question, this one is from July 21, 2006. That's 15 years ago. Answer, yes. And this particular incident is from Westside Electric. Answer, yes. Question, and the report is fallout on vehicles and parking lot earlier this morning, inspected vehicles. And you go a couple of pages further, and there is another inspection from Westside's complaints to JEA. They come out and do another report in August of 2006. And as a result of that, Mr. Holbrook testifies the resolution, and there was they were trying to determine where is the particulate coming from. Obviously, the plaintiffs thought it was the power plant next door. But at the end of this exchange, the ultimate resolution in 2006 was they had JEA come out and clean off the cars 15 years ago. And then they waited from that moment 8 years before they brought the cause of action. The steam was discharged continuously for 30 years. It's a single tortuous act. In all these other cases, like SDI Quarry, like the Millender case, you have separate independent tortuous acts. In Millender, it was when the DOT moved the channel of the river, causing erosion on somebody's property, but you had all these separate things happen. The government denied a permit for a seawall. Then they made them tear down a seawall. There were a series of separate tortuous acts. They all combine to create the inseparable harm of the erosion on the property. SDI Quarry from this court, same sort of thing. It's separate acts. We had one act they knew for a long time. This was a long period of time, and all this could be solved by just bringing a timely claim. That's all I have. We just ask you to affirm. Thank you.
Thank you, Counselor.
Thank you. What I just heard were great jury arguments about why my clients may have failed to mitigate properly. They're not statute of limitations. Read the RR case from the Supreme Court of Florida. There's very few statutes of limitations in Florida where a discovery rule applies. It's professional liability, it's products liability, it's fraud, and it's in some sex abuse. It's nowhere else. So when my clients knew or didn't know, it doesn't matter under the plain text of the statute. If you don't see me trespassing on your property, Judge Thomas, the cause of action is still accrued. So this is in red herring to argue to a jury about maybe my clients could have done a better job to mitigate their damages. It has nothing to do with the statute of limitations. I want to talk about the one act that we heard. So under this theory, and they've even said this, that if you come and you purchase a land later, like more than 5 years after the first trespass, then you're stuck with this person trespassing on your property forever. You can't do anything about it. That's their theory of the statute of limitations. Trespass actions, Ms. Harrell is incorrect. Trespass and nuisance actions do not run with the land. If you're fine with me trespassing on your property and you're fine with me walking across...
So your argument is, would you disagree with your opposing counsel that your argument is every time the wind changes direction, a new cause of action may or may not accrue?
I would
Because the
say,
salt's being deposited constantly,
well,
whenever the wind blows from a certain direction, right?
that's correct. Every
I
time
mean,
the wind.
his argument has to be correct, that your argument is, when the wind changes direction, like Wednesday, it's not deposited, Thursday it comes back, Thursday there's a cause of action.
Correct. That's what the statute says, when the last element of the cause of action occurs. And so you can't say that because the salt landed there in 1988, all lawsuits had to be filed in 1992.
It isn't, and I understand your textual argument, but isn't the underlying rationale of the statute of limitations to provide that causes of actions are brought within a reasonable period of time so that defendants can adequately defend themselves?
Yes, and these defendants are only going to have to defend themselves for the salt that was deposited during the 4 years preceding the lawsuit. And they're not responsible for the salt that was deposited before 2010. And just to go additionally on this, we have personal property that's been pled here. So if you were to drive your vehicle on this property in 2015, under their theory, and you got a lot of salt corrosion because you parked it there for 6 months, you're out, because back in 1988, the salt started. One of my clients has extensive personal property that's always been changing. So now they're forever barred because of what happened in 1988. Your cars, anybody who drove over there, nobody can do anything. They can just keep throwing the salt. That's their consequence of their argument. Once we start trespassing, we can't stop it. What if there's a change in ownership? One owner may be fine with the salt deposit, but when you sell it, you've got to get permission from the second owner to walk across his property or deposit salt. So if you sell your property, Judge Thomas, to Judge Roberts, then he says, Mr. Gowdy, I don't want you walking on my property anymore. Well, Judge Thomas let me do it for the last 5 years. Sorry. That's their argument. I just want to get to the pleadings and give you the specific record sites. So page 213, look at paragraph 22. That's the amended complaint. The third amended complaint isn't operative. We laid this out in the procedural history. Then go to page 751 and look at paragraphs 22 to 24. And then read the judge's order at record site 4432. And what you'll see, Judge Thomas, is that he didn't allow paragraphs 23 and 24 on page 751, but he left in 22 on those two pages.
Counsel, I'm going to ask you to briefly
Oh, I'm
conclude.
sorry. I
They
apologize.
actually left time on the table.
Yeah, I apologize, but those, I don't have anything else. Those are the record sites, and what Ms. Harrell was talking about, or is what pled in the inverse condemnation counts. We're allowed to plead in the alternative. The trespass counts and nuisance counts, I gave you one example, but you can look at every count. You will see
Counsel.
the repair and remediation. Thank you.
Thank you for your time.
Bye.
Thank you both for your arguments. Court's in recess.
All rise.